Well, good afternoon. My name is Michael Cooper. I'm a Chartered Building Surveyor, Fellow of the RICS, Chairman now of the Boundaries and Party Wall Panel of the RICS, and immediate past Chair of a learned society called the Pyramus and Disby Society. There are a few familiar faces in the room, but because I'm not quite sure where any of you are in the world of party walls, I'm going to start with just a few little basics. Anybody who wants to ask questions at any time, feel free, put your hand up. I'm not adverse to somebody jumping in or even having a comment or two, or even if you want a nice robust argument, please go ahead. So the Party Wall Act, I put this talk together as the Act has been around since 1997. It came in force in 1997, it's the 96 Act, and very little has changed. In fact, there's only one section of the Act that has changed, and it's section 15, and that dealt with electronic communications. But the Act and the way we use the Act is constantly evolving. And one of the things that we're going to do in the RICS later this year is rewrite our guidance notes again. So let's start right at the beginning. Where does the Act come from? Well, we did a little bit of research, and the first mention of party walls was actually in Roman times, when a chap called Vitruvius wrote books on architecture. But I found out an interesting story that apparently the Romans used to meet in the bottom right corner of their gardens once a year and celebrate neighbourliness. Something I think we should do today, but also made me think that there's always somebody left out if they only meet at one corner. But the first real legislation in this country dates back to the Great Fire of London, or the year following the Great Fire of London. And when people were putting the buildings back together again, they had a shared wall. And the first person that came along built that wall, and the second person came along and used it. So a bit of legislation was introduced to enable the person that built the wall to be reimbursed by the person that was going to come along and use it. And they had to leave teething in the wall for the better joining of the adjacent property. So this is the first bit of legislation that sort of deals with party walls. A load of local acts followed, culminating in the London Building Acts Amendment Act 1939, Part 6, which is the predecessor to the Party Wall Act. Prior to that, there was the Law of Property Act 1925 that only enabled you to make use of half the thickness of a party wall, not the whole thing. So there's a little bit of background. It's been around for a long time, and you can see how it's evolved in that time. The basics now, but some of those more familiar with party walls, there'll be a bit in here as well for you, I think. And that's a reminder. The Party Wall Act is an enabling act. It enables construction, but it also prevents disputes arising. Unfortunately, the definition of surveyor isn't determined in the Act. And there are a lot of people now taking on party walls that I think shouldn't. And there are a lot of disputes that arise because surveyors wouldn't have an argument. We're not there to make arguments, we're there to resolve a dispute before it happens. And that's something I try and remind surveyors of on a daily basis when I meet them on site. When we talk about the interpretation of bits of case law, that's really for us to have a little debate over, rather than involve the owners in disputes over what we think is right or wrong. Clearly, there are times when you might want to go to a third surveyor, and I'll explain that in a minute, to resolve a difference of opinion. But it shouldn't be an argument between surveyors. It's simply, I don't believe it means this, I believe it means that. And that's basically what case law has shown us the results of over recent years, and that's why we're here today. The Act itself, being an enabling act, obviously now gives people rights to do things to the entire wall, and it also gives you an unusual bit of something that doesn't exist elsewhere in English law. And we all think an Englishman's home is his castle. Well, this Act flies in the face of that, and it gives people access to neighbouring properties for the right reasons. Again, just on the basics, I'm going to explain some terms. So for anybody who's not familiar, a building owner is a person desirous of doing the work, and they are required to serve notice for various actions that they're going to perform to a party wall or on or near to adjacent properties. And an adjoining owner who's entitled to receive notice is anybody with a legal interest of over a year. And that could be the freehold owner, a tenant, or even a subtenant. they are entitled to receive notice of these intended works. You serve notice for works to party walls. This is clearly a party wall. The wall sits astride the boundary, it's shared by two properties. The boundary doesn't have to be through the centre of the wall, it could be through any part of the wall, but providing it's shared, it's a party wall. The second definition, this is the one often forgotten about, is where somebody's come along and enclosed upon the neighbour's wall, and they use it now as an enclosing wall to their property. Now that is a party wall to the extent that it's enclosed, not the bit above or the bit beyond on plan, but only the bit that's enclosed. Now whether that or not that has been enclosed legally, i.e. if it's a trespass, or with consent, or by just longevity, is not for us party wall surveyors to determine. The party wall surveyors take, as a matter of fact, what they see. The wall is used by both parties, it's party. If the boundary is on the face of the wall, then it's only party to the extent that it's enclosed. So that's a Part B wall. And then to do work to these walls, you have to serve notice. There are 13 permitted rights, 13 things that you can do to these walls. You can underpin them, you can raise them, you can chop bits off, you can do all sorts of other bits and pieces, putting beams into them and so on. And then also, this is called the Party Wall Etc. Act. Now the etc. you're going to find is probably the biggest part of the Act, although the smallest part in letters. And the etc. is to do with how we interfere with other people's properties. And there's a bit in the rights to be able to enable you to do something which is cutting in or weathering to join two properties that are independent of one another. So again, there's no party wall here, they're two independent properties with a boundary somewhere down the middle. And you have a right to enclose that by put a weathering junction between the two properties. That's one of the first obligations that is in the etc. The second bit is, of course, the Section 3 and Section 6 notices. Now I'm starting with the basics here. For those of you that heard it all before, terribly sorry, but for those that haven't, hopefully this explains some of the terms I'm going to be using. Section 6 notices are served for any excavation or foundation work lower than the neighbour's properties and within a 3 metre distance. Okay, so you serve notice for that. If you're outside of 3 metres but within 6 metres and you are deeper than and cutting what we call a 45-degree line, then you must serve notice for those works. Doesn't always mean it's the immediate neighbour. Sometimes it can be the neighbour but one. In narrow properties or ones at odd angles or a crescent or something, you may have multiple neighbours within that 6 metre zone on whom you've got to serve notice. Interestingly, I've always asked this question, the distance is the nearest point of the foundation to the nearest point of the foundation. The 45-degree line is taken in a slightly different place. It's taken on a plane of the wall above to the bottom of the foundations. So it's safe to say that if you're 5 metres away and you're going 5 metres deep, you've probably got to serve a notice. But if you're 5.1 metres deep, you might have to do the maths. Okay, so just bear that in mind, because the 45-degree line is a different place to the horizontal measurement. And then, of course, we have to serve notice also for works up to a boundary. So that now begs the question, we have an expert in the room, what's a boundary? A boundary is a pencil line on the ground, or it's whatever the owners decide equally between them it's going to be. Land registry really doesn't help, that little red line that we all get, right up to scale, it's about 2.5 metres wide. You try telling an owner that the fence really isn't in the right place, you know. But we won't go there, and the reason we won't go there is, and I'm going to come on to that in a minute actually. So you serve notice. If you want to build a wall astride the boundary, you can, but it needs your neighbour's consent. So you build it as a shared wall. Now that has some benefits. If you're building a little rear extension, you gain an extra ½ a foot, and your neighbour gains ½ a foot if you share the wall, rather than having 2 walls next to each other. But only if they agree. Otherwise, you've got to build up to the pencil line. Now you have to serve notice for building up to a boundary. And I have surveyors that constantly show me architects' drawings. We're not serving Section 1 notice, we're not serving notice for this, we're an inch away. Well, whoopee-doo, but that's no good really. And I'll tell you why that's no good, because you've got to construct that wall. So don't try and get away with not serving notice and saving a few pounds in surveyor's fees, because your owner's not going to thank you when they can't build it, because their builders can't go in next door. So you have rights of access under Section 8 of the Act to do works that's notifiable under the Act. So if you have a notified building up to the line of junction, you can go next door to build it. So use the Act sensibly, it's an enabling Act. Okay, this is where I have discussions with surveyors. Where do you think you are on this chart? You know, and everybody likes to be the font of all knowledge. Most of us sort of don't lay claim to that. We go tap of occasional insight. But the reality is, either those, that end of the scale, sometimes don't help clients. You know, I turn up to site and I'm dealing with a party wall issue, and the other surveyor says, "Oh, there's a rights to light claim here." So no, we're here to deal with party walls, you know. So settle down. I know you know all about rights of light. By the way, I've just written the guidance notes for the RICS, but we won't go there. So what I'd say is just be a little bit careful. And I take the words of Judge Bailey. Judge Bailey gave a talk to the faculty of party wall surveyors, which is another organisation that provides CPD. And in that talk he said, you've got to be intra-virus in what you do as a party wall surveyor. You've got to be within the Act. You're not there to step outside and start talking rights of light. You're there to deal with the Party Wall Act. So be within the Act. I agree with that. Be impartial. I agree with that. And there's a debate over this. We are considered within case law as quasi-judicial. Quite what that means, nobody quite really knows. But really, we're there to administer the Act and not take sides. It's very difficult to do when you've got a building owner who wants to do something. You can advise them how to use the Act, and that's fair. But if you start telling them to manipulate it, that's a different story. This is the bit I don't entirely agree with. He said you should give both owners the opportunity to discuss what is going to go on here. Actually, when you're appointed under the Act, you're there to administer the Act and resolve the dispute before it happens. I think sometimes you've got to be very careful just quite how much you take on board from a client or appointing owner. So that one I don't necessarily agree with. You've got to give proper consideration, you've got to think of the event thoroughly. So yes, the answer is, should party wall surveyors limit their role to determining matters in dispute? Yes, you've got to be intra-virus. And then that brings us back to boundaries. Should you be determining the position of the boundary? Right, so we go along, we've got traditional party wall, somebody wants to raise it, we all go, right, that's a party wall, you can raise it, okay? It's actually not for us to say that's a party wall. It's not for us to say where the boundary is. I was on site the other day where they've got a bit of a step, and one of them said, well, that's where the fence has been since 1977. And the other side is saying, well, it should be 100 mil over that way. What do you think? It's nothing to do with me. If you want to get into an argument over the boundary, you get into an argument. I'm going to take the determination of the person doing the work, the building owner. I will make my award based on that determination. It is not for me to determine where the boundary is. And if the other owner doesn't like my award, they can appeal it. And the appeal can be on the basis of a boundary dispute. And then the parties can resolve the boundary dispute in court. That has nothing to do with me, and it's not of my making. And it's not my role to determine that boundary. Now, I often say to clients on particularly complicated sites, have you had someone look at the boundary position for you? I suggest that you do, because we're serving notice based on what you're telling me or your architect is telling me. And believe me, architects use a lot of poetic license when it comes to boundaries. You better make sure that this is correct so you don't end up in a dispute in court on a boundary issue. It is not within the Act for the surveyors to determine boundaries. Okay? And that's what brings me now to case law. Intra-virus. Now for this I have terrible memory on names, so you have to forgive me. I do have a little bit of a crib sheet for my own benefit. This is a list of cases where surveyors have got it wrong. Okay? And I put this up to tell you, or to show you, how even very specialist surveyors are getting it wrong. And this is why the Act is evolving. Because what we think the Act says changes when a judge says it. Okay? Now, it doesn't necessarily mean the county court judge is right, but if it's the only case law we've got to go on, a lot of people hang their hats on that. It's really when you get a binding decision in the higher courts that you can really hang your hat on it. So Gray versus Elite Town Management. Now that one is where the surveyors unlawfully awarded what we call special foundations. If you don't know the term special foundation, I'm going to come on and explain that, but I'm going to explain that in a lot more detail based on another case. So forget that for the moment if you don't know the term. The second one, Shah versus Power v Kyson. Well, this is an old chestnut that's been going on now for years. It's gone through all the courts. And the outcome of this is if you don't serve a notice, you can't use the Act. Now, a lot of people are using that as an excuse to say, well, I won't serve a notice, full stop, and I'll just do it under common law. Well, there are cases, and I'll come on to those in a minute, where people that have chosen to ignore the Act have everything thrown at them, including having to take things down once they've built them, because they didn't employ the Act. And common law does not provide. You can't say, I'm going to use the full thickness of a party wall. Common law doesn't provide. So if you haven't used the Act, which is an enabling Act, then you cannot use the full thickness of a party wall. And common law will provide for that having to be taken down. The next one is an interesting one. It's the my opposition, as I call it, being the faculty versus the pyramids and TSB. We should be like that. We're all there to provide CPD. But this is a case of, not the surveyor getting it wrong, but this is the chairman of the other organisation who was called into question as a third surveyor for not attending site to see things physically on the ground. What's interesting though, and the interesting outcome of that case, was that when we make a determination, and this involved damage as a consequence of works, when we make a determination as to whether or not the building owner is responsible, we have to be intra-virus within our jurisdiction. The Party Rule Act only deals with notifiable work. If damage was caused by something else, it's nothing to do with the Party Rule Act, and it's not something we can resolve. So if somebody runs a JCB through the side wall of the building, and that JCB was being used for something that wasn't notifiable, it really isn't for us to resolve. It's a matter between the owners. It becomes a matter in common law. The next Act, Evans versus Patterson, a well-known surveyor I know well. These are two surveyors that went along to a property post-construction, and they saw wonderful cracks everywhere. So they went away and they awarded something measly, £3,000 to £5,000 worth of remedial works, and the award was appealed. But the award was appealed not on the basis of it costing £3,000 to £5,000. It was appealed on the basis that the building owner, the person that had done the work, had no idea that he caused any damage. And the surveyors had determined that he had to pay, but he said, well, there's no dispute. I would have paid. I'm not now paying the surveyor's fees as well. I would have paid had I known I had to pay £3,000 to £5,000. Why should I now have to pay for an award? And the judge said, you're quite right, and threw it away. I think they've now settled out of court. So you can understand here, this is two surveyors getting a little bit carried away without actually thinking, oh, we ought to tell everybody what we're doing. There's a couple of cases of that. K Group has an interesting one where a surveyor decided to do that 11 years after the event, made an ex-parte award and made it against the wrong person. So yeah, just be a bit careful. Ash versus Trimmel, two very well-known surveyors, tried to deal with an issue of a leak coming in through the party wall from next door. Next door wouldn't let them in to determine what the cause of the leak was, so they made an award to give them the right of access to go in and determine the cause of the leak so they can work out what the remedial works would be. The judge says, no, you can't do that. You can't have access for yourself to make a determination on what you're going to do. You've got to decide what you're going to do, and then you can get access to do it. So, yeah, interesting. Rega versus Mills. They awarded, two surveyors awarded, but they awarded after they had already called in the third surveyor to make an award. And because the third surveyor didn't make an award, they made an award. But because they had already invoked the process of inviting the third surveyor to make it, the judge said, it's not for you to make the award, it's for the third surveyor. And Lyons Homes, well, this again is just where we need clear evidence of a dispute, because when they made their award, again, no dispute had arisen. They made an award and the notices weren't disputed. The Party Rule Act, I mentioned previously, it can be administered by anybody. Your neighbour's cat can call themselves a party rule surveyor if they can speak. So anybody can be a party rule surveyor. This is a big problem. And some of the big firms use graduates. This is the RICS consumer guide, and we put it in there because we're RICS, only use RICS surveyors. But that's because we're shouting the benefits of RICS. What I really wanted that to read was use a competent surveyor, whether that's an engineer, an architect, a surveyor, but somebody that really does understand construction. And this is why I received a notice in my office when I was working for one of the big boys up in London. And it landed on a graduate's desk. And the graduate said, "Oh, I'll do this one. It's a flashing between two properties that they need to cut off." So I said, "Oh, no, hold on a minute. You're not doing it. You can do it, but it's in my name." And then the next notice landed. And this is what they ended up building. So the first notice would have had a graduate appointed as the name surveyor, had it not been for me saying, "No, put it in my name just in case." This is what we ended up. It's in Kensington High Street. 3 stories of basement, quite a lot of engineering. That's the party wall over there on the left. So you can imagine why we wouldn't want the grad dealing with this, okay? Somebody needs to, if you're going to do it, be a competent surveyor. Understand also your limitations. There's nothing wrong with a surveyor saying, "You know, I don't really get this bit," and asking an engineer to help, or an arboriculturist, or somebody else. But you need to know who to ask, and not what the right questions are. You know, what type of monitoring they're going to put up might not be a question an engineer asks, but you may lead your engineer to ask that question. And then that brings us on to this, which is, it looks like a typical bit of work, a bit of gutting out on the inside, and the consequence of somebody getting it wrong. There are 2 eminent party rule surveyors involved with that. I understand it was nothing to do with the party rule surveyors who had awarded temporary works, but the contractor didn't put temporary works in. So that happened. So, yeah, it's a word of caution, really, to anybody saying, "I can do a party wall." So what's changed? I'm going to concentrate on the top 3 cases here. But the bottom ones are all worthy reads. I think you've got a note in your packs of these. And some of these deal with the consequences of not serving notice, having to take things down that you built, etc. The top 3 I'm going to concentrate on, and the reason I'm concentrating on them, going back to a term that I used earlier, special foundations. Now this is how the Act has changed, and this one is, in my view, a bit of a comic farce. But it was Judge Bailey, and it was heard in the I think it was he heard it in the technical court, I think, but acting as a county court judge. What happened is, up until this case, special foundations are referred to as an assemblance of rods and beams. Towards the end of the last century, this was a sort of typical pad foundation that once it crossed the boundary, you just couldn't get rid of it. So you needed your neighbour's consent to build any foundation that contained reinforcement and crossed the boundary. Nowadays, we underpin in a very narrow strip. We all know that's a sensible underpin, okay? So we don't have this anymore, we have that. But for years, because it crosses the boundary, it sits centrally to across the party wall, you've had to have consent of the neighbour. But in this case, they said, that's not actually a foundation. That is a downward raising of a party wall. So the Party Wall Act enables you to raise a party wall. They said, we're raising the party wall downwards, and we're putting a little lump of concrete at the bottom. That's not reinforced, but that's the foundation. The rest of it is a downward raising of the wall, and that's the foundation. And the judge said, yeah, okay. So they didn't need consent. Now we call that the Bailey rail, after Judge Bailey. It's not great to include that in your design, because clearly when you have to dig the little patch out right at the bottom, you've left the whole pin above it open, and God knows what's going to happen with all that loose soil and gravels and everything else the other side while you're waiting for that concrete to cure. So it's not a good thing to put in, but it does get you around the need for consent. What I do is I say to people, consent to it, and then we won't get a lump of concrete and your property's less at risk. If you don't consent, you're going to get a lump of concrete and a risk to your property. But this is...
Was that appealed in a higher court?
No. No. So that's, as far as we know, fairly binding. But surveyors have jumped at this saying, wonderful, fantastic, because now we can do a proper underpin. We don't have to use mass concrete, which will be a waste of space and time and money and cause more risk to the adjacent property. It's a sensible design. So that's one way the Act has changed. The need for a special foundation now, put a lump of concrete and do a downward raising. Another landmark case is Russell Gray and James Crowley. This was last year. And this hopefully answers a few questions on surveyors' liabilities. We are there trying to administer the Act. And just recently, some London-based solicitors and barristers have tried their very best to try and sue surveyors when they've got it wrong. Now, if you sue a judge, that can't happen. And as I see it, our role was quasi-judicial. We're the first judge in the line of judges. If we step outside of our jurisdiction, then fine, sue us because we've done something we shouldn't be doing. But if we made a judgment and you find that wrong, you can't sue us. Another judge can overturn it. You can appeal the award, but you shouldn't be able to sue us. This case, County Court case recently, has answered that question, and in the following way. The judge, this is actually a third surveyor's award that was appealed, but they tried to sue him, and he said that that it should be, it's a quasi-judicial function, so it should follow that there's immunity. And he said that, we had the benefit of immunity in carrying out a statutory function. And then also he went on to say, and it should negate any duty of care that might otherwise be owed. So in other words, if you stick within the Act and what you need to do, and you've got it wrong, you're immune. Somebody can appeal your award if they don't like it. They can't just sue you because they don't like it. So then, this is more case law. This is interesting. It's changed the way we all think about fees. Fees is another subject, and I'm going to do a roadshow on that next year. But fees are normally paid by the person doing the work, the building owner. The cost of surveyors is part of the cost of doing the work, okay? Occasionally, if there's, say, a party wall in need of repair, the surveyors can apportion costs to each of the owners based on the use that they make of that party wall and the responsibility for the defect or lack of repair. So they can go, well, okay, right, well, you kind of half knocked it over, you pay 50%, you pay 50%, and they can include fees in that. But normally the person is doing it for their own benefit. They're building an extension or something like this. In this case, the person that was doing the work said, I actually served you notice, I got it offline, and you picked a surveyor, so next door picked Joe Bloggs, and they said, I want to use Joe as well, please. And the neighbour said, no, I want the two surveyor route. I want you to get your own surveyor. I don't want you using my surveyor. And that went to court, and the judge actually said, well, that's a bit unfair. You picked a surveyor you're happy with, and why won't you let him use it? No, you can meet the cost of the extra surveyor. So that was a bit odd. Having said that, though, I think if the surveyor that was acting for the neighbour refused to act for the developing owner, then I don't think that the joint owner would have had to pay the cost, because I think it's our right as surveyors to determine who we want to work for or not work for. So, but it was the owner that said it in this case, and I think very bizarre judgment, but there was a big history to this. It's well worth a read if you get 5 minutes. But the history is basically that the same happened the other way around earlier, and they had let them use the same surveyor, and then all of a sudden they all fell out and went, no, get your own. You know, so it was a little bit more than I want the two surveyor route. It was no. But anyway, we won't go there. So right, the next one is this is a big chestnut. This is surveyors saying, I need to go back at the end, make sure everything's all right. So has it been built in accordance with the award, and is there any damage? And there's a debate. Some surveyors are saying you shouldn't get that money, you shouldn't have that money in advance, you shouldn't have that money in the award, and there's no need to do a second survey unless the owner complains of damage. I don't agree, and there's several reasons. The Act itself, Section 13, deals with reasonable inspections. Okay, well, what is a reasonable inspection? Is it reasonable to assume that your owner is going to know if his property's been damaged? The answer is probably no, unless it's just a beam in the wall. If it's just a beam in the wall, I don't think I would go back unless the owner complained that there was some cracking. But if you're building an extension, they don't necessarily know, what damages may have occurred to their property. They may be looking inside and not outside. So it takes a trained eye to recognise that damage has been caused to a property, and I think it's reasonable to go back. So a reasonable inspection. Secondly, if you go back to Hansard, and this is John Lytton, when he was talking in the House of Lords, which incidentally, this is my claim to fame, because I had a little bit of a dispute with the government over HS2, and we ended up assisting with trying to make amendments to the HS2 Phase 2, because they made their own provisions for dealing with neighbours and ignored the Party Wall Act. So I had a bit of a tussle with them, and John Lytton put our tussle forward to the House of Lords to try and get an amendment through on the legislation, and he said, and I quote, "Thank you to Michael Cooper, Party Wall expert." So anyway, we won't go there. But it's in Hansard, so it's got to be better. But no, the reality here is that so Hansard actually said, this, and this is John Lytton saying that it's essential for surveyors to draw up schedules of condition and have access to adjoining owners' properties effectively. So he is already saying a survey is required. He doesn't say much about the second survey, but I still think that it's necessary inspection. So we can debate that one later if anybody disagrees. This is something here that quite often those that deal with the administration of the Act all the time pick up their copy of the Act or the Green Book or whatever it is that you use and say, right, what am I allowed to do? And I sat in the office and somebody said, I want to raise a chimney. Okay, so this is a party structure. It's shared between two owners. The flues are shared. But what do we do when we get to this? With the party wall sitting there, somebody wants to raise the party wall, yeah, and this flue is theirs and that flue is the neighbours. You're raising the party wall. And I said, well, no, you've got to raise your neighbour's flue. Couldn't find it in the Act anywhere. Then I flipped past the end of section 2 and all the subsections, found it in section 2.3 eventually. I knew it was in there, but I just couldn't find it because it's not something I use very often. It's not a right, it's an obligation. If you raise the party wall, you are obliged to raise your neighbour's flues to a height that they can still be used. So there are obligations in the Act, and I forgot. I thought it was a right, but it's actually an obligation. So reading the Act is something that one has to do. Who should we...
Sorry. I'll ask you a question. Does that apply to the kind of, if you were going to build a loft conversion to the rear, and someone's kind of half used the parapet wall as a structure to put their stud work on, shouldn't they have kind of raised the whole of them? Wouldn't they have been required to raise the whole of the wall?
You should raise the full thickness of the wall if you're raising the wall.
Does that only apply to a chimney, or does that apply to a parapet wall as well?
Parapet wall as well. If you're raising the party wall, you raise it for its entire thickness. It has to be equitable. It has to be able to be used by both parties. So that's my view, although that is debated because it hasn't been settled in court. But yeah, by all means, quote me. So who do we notify? Well, we've talked about the owners next door, anybody with any legal interest of over a year as an adjoining owner, tenants, subtenants, etc., 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 and we must serve notice on them. We went on to read, though, when you serve a notice, one of three things can happen. The neighbour can say, I consent, so you get on with it. They can say, no, I don't agree, and they appoint the surveyor, or they say, I don't agree, and they appoint the same surveyor as you. The consent one, though, if you read the section of the Act, it says nothing prevents you from carrying on the work subject to consent, but you need the consent of the adjoining owners and the adjoining occupiers. Now, that's something I'm not quite sure has clarity. What is an adjoining occupier if it isn't an owner? And why is it separated? Does that mean if you've got a 6-month tenant, we've got to ask their permission as well? I don't know, is the answer. But that's a little anomaly in the Act. The Act needs rewriting. Go ahead.
Supposing you have a squatter who is occupying that land.
Exactly. Exactly. Now, the definition of owner or adjoining occupier may mean the same thing. If you go back to early parts of the Act, it says serve notice on owner and occupier. And an owner is defined, but occupier isn't defined. So it's been an interesting thought. I haven't seen that come up yet.
And the same leaseholder, freeholder?
So an owner is defined as anybody with a legal interest of over a year. So any leaseholder with a 2-year lease, or 5-year or 999 year is entitled to notice, and that can apply to a subtenant with a long lease. But an occupier doesn't have to have any legal interest, but they may be entitled to be involved in the consent process. I haven't seen that one tested, but this is where the Act is evolving, and this is what I mean. That's going to eventually get decided. The Act would have moved on. Hopefully it will move on to a new version. But
so I've got another one where I've got a tenant. Tenant has got their agreement with local estate agents. Can we then serve notice on that tenant and on the people renting the property to find out who the leaseholder is or the freeholder, so we can serve notice? Is there any right in the Act?
Land registry you can use for freeholder. But, no, I'll tell you what I do, and this is, whether it's right or wrong, I'm not sure. The Act says you must serve notice on the owner. Okay? So I serve notice on the owner. I also do my research on who they are, so I serve them named. And if somebody comes out of the woodwork and says, I never got a notice, well, no, you did. I addressed it to the owner, and you're the owner, by definition under the Act. So I serve an additional notice addressed to the owner, and hopefully that covers those entities that may come out of the woodwork. But you try and ask people as you go, you know, and one of the first things I do when I serve a notice is say, please let me know of any other interest, either as an owner or occupier or freehold interest. So I try and ask the question. And I think if you went to court, you started work on site and somebody goes, well, I have an interest, but I've been living in Hong Kong for 36 years and it's remote, and the judge is probably going to go, well, tough. But if I've served notice on the owner as well, if they did come out of the woodwork and I haven't made my walls, I've got time.
And that's if you served it to the owner at that address.
At that address.
That's all you've pinned it on the front.
Yeah, at that address, yeah.
Can you just also add adjoining occupier as well to the owner? Adjoining occupier, which goes to cover all bases.
No, technically that consent thing is different because they're not entitled to notice. So that was me putting a red herring out there, as it were, because I don't know the answer, but it's interesting when you read it, there's that little extra word there, and I don't know why it's there. I don't know why it's there, and nobody that I know can explain that to me, but it's food for thought for the future. So, okay, third surveyors. These are the people that you go to when you can't agree. I am a third surveyor. I've just dealt with one that's gone, it's actually going to appeal, so I won't tell you too much, but the award that I made was for £1.8 million worth of damages to a property, with one side claiming they only did 600,000 and the other side actually asking for 1.8. My calculations came out 1.8 in a completely different way, but nevertheless I awarded 1.8 million. That's the kind of dispute that you go to a third surveyor on, not £300 worth of fees. Okay? So please, don't go to a third surveyor and say, I'm having an argument over, he's charged 1 hour too much, or his rate's too high, or something like this. Get together and try and work it out and work it through. Some people will charge very small rates, might not have much experience, fair enough, but if you've got 30 years of experience like I have, my rate's going to be higher because you're paying for that experience. And if I have to spend the time, I have to spend the time. I don't really want disputes over my rate because it's a little bit too much or not what the client expected. You've got to raise the expectations of the adjoining owner, or sorry, the building owner from the outset, that you may be paying another surveyor more than you're paying me because their rates may be different or less even. So this is for you to determine. When it comes to picking a third surveyor, I don't think it matters geographically where that third surveyor is based, but if it is for a domestic property, use a local if you can. But you know, Zoom is available always nowadays, that we can discuss things on Zoom. And I, as a third surveyor, as do a couple of others, offer a free half-hour Zoom to weed out things like fees and say this is where I would go if you came to me formally for an award. And I think that helps resolve minor disputes without, you know, at least putting the minds of the surveyors at rest that their arguments are valid or not valid, as the case may be. More complicated, doesn't really matter, but choose wisely. This is, for those who haven't read them, because they do send you to sleep, various guidance that the RICS have produced, owners' guides and surveyors' guides. This is helpful if you want to set out the services you are going to provide. It's a tick box form saying, no, I'm not going to determine boundaries, but I will do a party rule survey and things like that. The current guide, we're going to rewrite this at the end of the year. There's going to be a slightly amended version of the new award at the back, but only slightly. And there are other things that I'm going to include in there, such as, if I can, if the RSS will let me, such as what not to do and what bad behaviours are. But I'm not sure the RSS is going to let me do that, but I'm going to try. But also, bear in mind it's going to be rewritten in India. But for those of you who aren't using the new RICS standard award, it is very, very good. It's written primarily by 2 barristers, and then the surveyors got hold of it and rewrote it, and the barristers aren't happy anymore, which always makes me smile. But it's written for surveyors, it's used by surveyors, and there's a good section of the Act now that enables us to deal with things that we can't award, but we've relied upon to make our award. So there's an introduction section where you can say, well, the 2 surveyors have agreed, the boundary's here, so we are making the award based on that agreement. That's not for us to award, we're not determining it, but that's what we relied upon, and they've showed us this documentary proof or something. So you can put that in your introduction. I've relied upon this to make my award. Very helpful, I think, but not something you are awarding. So if you haven't used it, go ahead. At that point, I'm not sure where we are in terms of time. Are we? Quite early, good. Because I can go back. But first of all, let's just take a few questions first of all. But
So Michael, could you go back to the section we spoke about where the reinforcement was in the toe of the ground beam? You made the point, didn't need to serve notice. I noticed in the section that the, if you will, that's the one. So the left-hand section 2.2 seems to me, you can tell me otherwise, is that rebar in that height beneath the wall to the toe of the
yeah, it's an underpin.
Okay, but not construed then as being special foundation because of rebar?
No, it's a downward raising of a wall.
Just hallucinating then?
Right. So the wall has been raised in a downward direction. Yes, it's a foundation, but no. The foundation is the artificially formed support on which the wall rests. The lump of concrete that doesn't have reinforcement in. It's a separate item to the section of raised wall in a lower direction above, if that makes sense.
Like a technical word really, because I mean, in all essence, it is.
We all know that, yes. We all know it's a farce. But yes, I get the logic. The lump of concrete, the foundation, is not reinforced. It's a wall, for all intents and purposes. If it was above ground, it would be a wall. If it's below ground, still a wall, technically. Although we all know it's an underpin and it's a foundation, it's not classed as a foundation. That little lump of concrete is the bit that we're relying on as the foundation. Yes, I know. But it has done away with the need for consent, provided you put it in. That's the actual drawing that was used in the case. So that's not one that I made up, that's the actual drawing. So if you want to use this, I suggest you use that drawing as a baseline for any design, rather than trying to cobble something together yourself, unless you're a design engineer.
Second question, I'm going to jump in when I can. I've had notices where there are section 1, section 3, section 6. Surveyor was arguing only need to serve one section. I made a point that you need to serve on 3 if that's validates what you're doing.
Yeah, the Act is quite clear. The works are different for each section. So recapping, section 1 is for building up to or on a line of junction. So that's a new wall that where the boundary's not been built on other than as a boundary wall. Okay, so it's a virgin boundary for all intents and purposes. I had a very interesting scenario with that one, where there was a building up to the line of boundary. They served a section 1 notice, and I said, no, the Act says it's a boundary that's not been built on. This is a boundary that's built on. Yeah, so up to the boundary it's been built on. So they demolished it and then served a section 1 notice because they said, now it's a virgin boundary. I thought, well, that's a bit of a farce. Went to the third surveyor, he agreed with them. That was Alistair Redler, who's now retired. My owners didn't want to fight it, but I kind of felt that was a bit of a farce. But now, having read it, I understand the Act is clear. It says a virgin boundary. It doesn't define what a virgin boundary is. It's a boundary that's not been built on. It wasn't built on. The ball had been taken down. So that's section 1. Section 2, for which we serve notice under section 3. Okay, section 2 is the 13 permitted rights. So if you're doing any of those, you have to serve notice. And then section 6 is the foundation and excavation. Again, that's a completely different thing. Bear in mind, with section 6, there's no such thing necessarily as a party wall. Okay, these are two buildings that are apart from one another by a distance. There could be a party wall. So if you're underpinning a party wall, I think you have to serve a section 6 notice and a section 3 notice for the underpinning, because you are within 3 metres of the front wall of their property with an excavation or foundation on the boundary for which you're serving notice under section 3. Does that answer your question? But yes, each action requires a different notice. Okay?
When issuing a party wall notice, is it true that if you don't hear a response within 2 weeks, it's automatically accepted?
No. Right, so there is a bit of an anomaly because section 1 requires a dissent, whereas all the other sections require a consent after 14 days. If they don't consent after 14 days, it's a deemed dissent.
Oh, okay.
So, and a deemed dissent requires then that you serve a further notice, which is what we call a 10-day letter, giving them a further 10 days in which to appoint a surveyor, at the end of which your owner, unless you have the authority in your appointment letter, your owner picks a surveyor for them. So they then appoint a surveyor for the neighbour. A lot of us in our appointment letters take the right to make that appointment on behalf of. So we appoint the surveyor. But if you haven't got that written into your appointment letter, then it's the owner that has to make the appointment of the surveyor for next door. But the 14 days and the 10 days, when you serve notice, and the correct method of service is normally post, you have to allow an extra day for postage. So some of us allow 2 days just to be on the safe side of the law, but it's actually a day, I think. Unless the neighbour has agreed to receive electronic communications, i.e. emails, then you cannot serve notice by email. Okay, and that has to be written consent to receive notice.
Just off that, if you don't receive a response, full stop, and like you said, they were living in China for 30 years, and what's the situation then?
So you appoint a surveyor for them, and the 2 surveyors determine an award.
Okay.
You can't appoint yourself as an agreed surveyor. Okay. Sorry. Go on.
Do you need to serve notice to maintain the party status?
To maintain?
Yeah, just
to carry out work.
Repointing or
Yeah, technically, yeah. My new type of work is very difficult. Putting a nail in the wall technically is a notifiable act you're cutting into. Technically, it's a notifiable act. But the event is over so quickly and the consequence isn't there. So anybody taking an injunction out because you put a nail in the wall is likely to not get heard. Having said that, there was a case where one side served an injunction for someone that was can going off the render on their side of the party wall. But because it was being cangoed off and it was a horrendous noise, they injuncted them. And the judge said, yeah, you should have served notice, you're cutting away from a party wall. So I don't quite know where the line between reality and, you know, what's, you know, I would suggest if you're repointing the chimney stack, you know, I wouldn't be serving notice personally, and that's the kind of advice you've got to give to a client off the record, because technically under the Act, you should be serving notice.
Going slightly tangent, I'm getting fed up with licence for access. Is there any movement or talk about addressing access issues which don't come under the Party Wall Act or Access to Neighbouring Land Act?
Right, okay, so I manage the iServe account for the Access to Neighbouring Land Act for the RICS, and I'm asked every year to rewrite it, and every year I go, oh, well, nothing's happened, because there's no case law on it, very little. The Access to Neighbouring Land Act is a bit of an ass, because you have to go to court, you have to get an access order, and that's going to cost you 20,000 quid. So come to an agreement with your neighbour, put an access agreement in place. The Party Wall Act obviously gives you rights of access for work under the Act, so using that in the right way. The preservation and maintenance of buildings comes under the Access to Neighbouring Land Act, but no, an Englishman's home is his castle, bearing those two acts. So an access licence by negotiation, and negotiation clearly always brings with it consideration. Consideration can take many forms. I did a job for Berkeley Homes against the River Thames, and the chimney stacks were wonderful things. And the neighbour said, I want 4 of those in consideration of your crane going over my property. So that was written into an access agreement. So, you know, strangely enough, there's all sorts of different considerations, but the answer is, no, you have no right. The only people that have rights over your airspace are the Queen and the aviation authorities. So, and that's it.
No, I appreciate there's no sort of automatic rights or rights there, but under Section 6, for example, that this follows a similar vein, really, because Section 6, for foundations, if you need to go onto an adjoining owner's property to construct foundations, that's not addressing a shared structure, it's not addressing a shared...
Oh, no, this is where you may be wrong. If it's pursuant to the Act, Section 8 applies. Okay?
No, I follow that.
So, when you have a rig head oversailing the boundary, because you have to put your pile in, you've notified the pile, then the rig head going over the boundary is permissible under Section 8. You can award it. If you have to bring your rig in a different direction in order to put the foundation in, there's a possibility you'll have a right of access to do it. So, if it's works pursuant to the Act, i.e. the construction of that foundation, then you could have a right of access. You've got to be very careful how you use that.
No, I'm very familiar with that. I'm just wondering if there were sufficient MPs being affected in Parliament or Westminster where their homes are, having to get licenses for license.
There is something I used a few years ago. You'll find this interesting. I was acting for a big new development. It was a Chinese-based company. They haven't actually built it. It was going to be the tallest residential tower in Western Europe, based in Docklands. They appointed me to serve notices. They'd started the groundworks, etc. But the neighbour, who are the Canal and River Trust, also appointed me as an agreed surveyor. And one of the things that they had to do was they had to put some temporary works in on the Canal and River Trust land. So some sheet piles, they had to put them in order to build the foundations before they put the pile cap up. So that was there basically to stop the soil falling in. And they said, well, can we have access? Can we put the sheet piling in on our neighbour's land? And I said, yes, providing it's capable of being removed and it's temporary. It's no different having scaffold above ground. So yes, I will award it, and I did. So I awarded them the right to put sheet piling on the neighbour's land. I got a phone call 2 days after I published the award from a barrister, and he said, Michael, I've got a really interesting one here. I've got an award that's landed on my desk. And it says this, is that right? I said, who made the award? He went, I didn't make this call. No. So that was the most interesting scenario I think I've ever had, but yeah. Sorry, yeah. Other questions? Right, so I don't know, clearly how long do we have?
Well, we can stop there, but tea and coffee won't be...
No, it's all right. How long do you want me to carry on for? Because I've got a couple of other...
Oh, no, 10 minutes.
10 minutes, good. Right. Oh, go on, yeah.
I'm new to all of this.
Right.
I haven't had the luxury of any of these confrontations. Building residential surveying world, particularly the focus on the vendor aspect of the adjoining property, where work has taken place against the party wall. What consideration, maybe 10 years ago, which probably the consideration is probably lesser than maybe work that's taken place against the party wall in the last year or so, relatively recently. What considerations are there for us as residential surveyors advising the buyer of the adjoining property?
That leads to some very interesting points. So first of all, the award post-completion of the work is still valid in terms of latent damages or damages arising for 6 years. And we've had that confirmed in recent cases. I can't remember the name of the case because I'm useless with names. But 6 years post-completion. The rights pass with the property to a new adjoining owner. When somebody sells it, the award follows to the new owner, stays with the property. Obviously the building owner's rights don't. They stay there with the owner. They're the one doing the work. Okay? But when an adjoining owner changes, the rights conferred by the award stay with the owners, or stay with the property rather, and convert to the new owner. So they have that same 6-year period in which to resolve damages. This is another reason why I think it's necessary for surveyors to go back and check that there's no damage or the works are complete. And I had recently, more recently, there's a lot of conveyancing solicitors now asking for historic copies of awards. And then asking the question, did you close your file? Is your file still open? Did you check the work? Is there any damage? When they're dealing with conveyancing. And if you can't answer that question because you never went back, there's a risk then to the purchasers in buying that property. So the seller is having a struggle selling that property because the surveyor never went back. This is why I think the surveyors need to go back. And for the building owner, the person doing the work, that says, I'm not going to pay your fee to go back and check next door, when they come and sell their property, they've got the same risk. But if they don't want to pay my fee going back, I'm not going back, ever. So they can have a problem selling their property.
Clarity on that, if I may then. So ultimately, it could be the case that if that award wasn't checked, that the building owner who's done the work could sit on not making any of the changes under that award for 6 years.
Right, so
it gets accepted into.
So when a building owner has the right to carry out work, they have no obligation to carry out the work. But if they do start the work, they've got to complete the work, or complete it to the satisfaction of the adjoining owner not still being protected. This is why we can get onto an anomaly here, security of expenses. Have you heard this term? Okay, so there's a section in the Act called security of expenses, where if somebody, if there's a foreseeable risk, and it has to be foreseeable, so it's not the risk of someone running a JCB through the sidewall, it's something that's tangible. So if you're underpinning a party wall, for instance, we know it's going to move up and down. We can do a Berlin scale assessment, which is an engineer's assessment of the category of damages that are likely to be caused to the adjacent property. And then we can ask for a quantum of money to be placed against that foreseeable risk of damage. We can also ask for a quantum of money against the risk of someone going bankrupt and leaving 4 pins open, for instance, in an underpin. So you've got to go in and fill that underpin in yourself to protect your property. So you can ask for some money to be placed on a secure client account, normally with a solicitor or with a company that does it, and then it's paid back when that's completed, or when damages are made good, or there are no damages. That requires a re-inspection, clearly, or they don't get their money back. And secondly, more reasons why surveyors need to go back. And secondly, obviously, this if the damages have been made good and the works are complete and there's no more risk, then they get the money. And vice versa, if they disappear, then the neighbour gets the money. And there are other pieces of the law. They give you rights of access to go in and carry out that work next door, which the Act doesn't, but you can do it by other means. Hopefully that answers the question. There was another question at the back?
Yeah, I was just going to say, I'm regularly involved with taking through from the measured survey, planning, building regulations, etc., etc. I find it interesting what you said about conveyancing solicitors asking about whether the file's been closed, because do you think that will allow actually to raise the perceived profile of the party board, etc. Act? Because we all know it's a very powerful thing. It's an act of parliament. Unless you know the king, there's nothing higher, right? Whereas, of course, with planning laws and building regs, you can go around them, regularisation, you can PD, etc., blah, blah, blah. Do you think that, given Shah versus Power and Kaiser and the whole no-no situation, which I agree with, but do you think if that had gone the other way, it might sort of just because I get, Larry builders denying the statutory rights of neighbours, and the neighbours are too afraid to go to the court to get an injunction to stop it. And I feel very powerless. I have to say, that's the answer. So do you.
Yeah, unfortunately, English law is an ass.
Yeah.
It means you have to
I'm
have money.
solicitor, so I fully agree.
Yeah. Well, you're not the only solicitor who will agree with this. You need money to enforce many parts. If you've got a tribunal, when you're leaving under duress from a job or something, you've got to have money to go and defend yourself. This is the problem. The Act is there, it's a statutory Act. You're obliged to conform to the statutory provisions of the Act, including serving notice. And if you fail to do so, an injunction could be upheld against you. You have the delays, potential risk and costs associated with that. The blasé attitude of builders doesn't alleviate the owners from the liability under common law for nuisance and negligence. So if something does arise, and they haven't served notice and they've got a blasé building, well, just about everybody's insurance is going to be affected by that one. Most likely the builder who ignored it, or the owner who told them to ignore it, or somebody. So the adjoining owner isn't without some protection of English law, but trying to get them to serve a notice when they've started work is nigh on impossible sometimes. And you're right, all you can do is say to the owner, well, you can injunct them. It's going to cost you £20,000. You'll probably only get about 70% of that back, even if you win.
Sorry.
So
You've said that figure as well. Is that just roughly, in your experience, a normal terraced house? Someone goes to do an extension, but they don't serve the notice and don't follow this process. Is that real figures you're talking about?
Yeah.
Is it really?
It's not unreasonable figure. I would say it's anywhere between 12 and 20 for something like that.
Right.
Because you've got the legal costs, you've got to turn up with a solicitor and a barrister, and you've got to build a case, and you've got to go to
That
court.
would be the neighbouring property would have to potentially, that would be what they'd have to cough up.
Well, if they win, they get some of it back. The interesting thing is actually the one case that I did have in that regard, it was actually with John Lytton on the other side. So John Lytton is remember the House of Lords took the Act through. I was wondering what our credentials were going to stand up against each other if we did go to court. But we did a joint expert report, so we agreed. It was basically it was a secretary in the office that I worked in, was building a garage, and they put the foundations in for the garage, and they got an injunction from this guy next door for not serving notice on a fish pond. It wasn't very big. But the question was it a structure? And John and I agreed it was a structure, but we also agreed, well, the foundations are in now, so the injunction's too late. And it was settled on the court steps. So interestingly, my secretary's fees to me were a case of red wine. And to her barrister, who was her sister-in-law, a case of red wine. John Lytton charged his side about £8,500, and they had barristers and solicitors' fees all lined up as well. So they kind of got punished for being stupid, But I'm glad that was the outcome, to be honest with you. And I said this to John afterwards. He said, "No, I was pleased as well." So he didn't like his appointing owner. But interestingly enough, you can try and reduce the costs if you know people, but that's the only way. Unfortunately, the legal fees, surveyors' fees, you need an expert, etc.
And just last question, just with regards to a structure that's been built to a neighbouring property on the boundary line, and it's not had any notices or anything of that nature, how far back can you kind of go back? So if a structure's been put up, there's not been a parliament notice served.
Right. Yes.
How far back can you go?
Okay. So if it hasn't caused any damage, then there's no consequence. Okay, so there's nothing much you can do. If a damage is because it's crossed the boundary, then that's a trespass. It might have to be taken down. Crossing the boundary includes raising the full thickness of a party wall, by the way. Yeah? So if somebody has employed what they think they're allowed to do under the Act, but didn't employ the Act, that's a trespass. Okay, so potentially they have to take it down. That case I threw up earlier at the bottom of one of the slides and said read it, that was that. Okay, so there is a consequence for not serving notice and doing something. But if you've done it and got away with it, and caused damage, well, you got away with it. Yeah. You're still responsible for any latent damage. Anything that happens as a consequence of that. We've got a lawyer in the room. Correct me if I'm wrong here.
No, I'm married to a solicitor.
Oh, okay, fine.
He's married to a barrister.
Yeah.
That's the way.
There we go. So, no, essentially, you get away with it. But is it worth the risk? In fact, there are 2 London barristers. I'm letting the cat out the back here now. Are trying to look at a cheap way of injunction for this specific thing. They are looking at the moment to do it, but in a friendly manner. If you've got a proper case, they'll take it on pro bono. So they're putting that together at the moment. Some of our London-based solicitors are very, very good. They're all in the party wall world now, and they're all taking degree courses in building surveying. So, yeah, God forbid. Thank you.